Every client we've ever had has employees or contractors or people who work for them, and employment law is all about managing those staff. So it might be about managing their performance, it might be about making sure you pay them the right amounts, it might be about understanding your obligations to them, it might be about managing the culture, whatever it is. Employment law is all about managing your workforce. Probably the most common thing we do is prepare employment contracts. So either our clients don't have them, or they need to update them, or whatever, or they're hiring new people. We'll prepare an employment contract, often that's different for the more junior staff than for the more senior staff. They need to include things like protecting the employer against poaching of clients. So if a senior person, say your marketing manager, knows all of your clients, can then go and start their own business and take the clients with them. So we need to have provisions to protect them from that. We need to make sure that they're paid correctly and that they're motivated correctly with bonuses and all that sort of stuff. But a big part of what we do is just prepare that employment contract and then write the internal HR policies. So policies on bonuses, policies on harassment, policies on whatever it is. And in order to comply with obligations and to create the right culture, you need the right policies in place. A lawyer is going to be able to deal with a much broader range of issues. Human resources type people can deal with, they could prepare policies for you, and probably to some extent they could do employment contracts and that sort of stuff, but a lawyer is going to be able to give you a much broader approach to dealing with unfair dismissals, dealing with redundancies, dealing with managing difficult employees, all that sort of stuff. And an employer is going to handle the legal bit a lot better. The reality is some of the HR policies are going to be sort of vague and unenforceable anyway. That there might be a place for that. Certainly in small business, you might go to the HR advisor first, and then once you get to a certain level, you might go, okay, it's time to get serious, if you like. But if you're going to end up in a court or a tribunal, you'd want to go to a lawyer to make sure you've done the right thing. I mean, an HR advisor might say, okay, well, you can, have a 3-warning system, which is fine. But then if you're going to actually terminate someone, they're going to sue you for unfair dismissal. You want some legal advice about your liability, the lawyer's going to be able to help you with that. The HR advisor is not going to be able to act for you in a tribunal, and ultimately they're not going to be able to tell you what your legal liability is. If someone's underperforming or someone's difficult, then it's not unlawful to terminate them. You need to be fair in the way that you do it. You need to give them a substantive fairness and a kind of a procedural fairness, but that's all doable. And then if they're still not able to meet the standards, then you're able to terminate them for performance reasons. If you were to make them redundant and they're not genuinely not needed anymore, then you expose yourself to an unfair dismissal. Redundancy is really about when a staff member is no longer needed, so they have to be genuinely redundant. So if you make someone redundant and they're not genuinely redundant, then you're in trouble. A staff member who's redundant is somebody who their role is no longer needed to be performed by anybody. So it's not that you don't like them, it's not that they're underperforming, it's that their role no longer exists. So if you make them redundant and then hire someone else to do that job the next week, they're not redundant, and that's an unfair dismissal. So then you're potentially liable to pay compensation. So it's in a restructure when you don't need that job anymore. A dismissal generally will be about performance. So a dismissal for performance reasons will be that the employee is not meeting the goals of the organisation, and that they've been notified about that, they've been invited to meet those goals, and then they still haven't been able to after a reasonable period. That's a termination for performance, and a redundancy is where that job no longer exists at all. But it's perfectly lawful to sit down with an employee and say, this is what we expect, this is where you are, this is where we need you to be, and this is how we're going to get you there. And if they can't get there, then if for whatever reason you can't get there, then this isn't the place for you. I run a very small practice with a small close-knit team, and performance managing them is difficult. Ultimately, the way I explain to my clients is I say you owe it to your own customers, and you owe it to your good staff. Because if somebody's underperforming, then they drag everybody down. Other people need to step up to fill the gap, and customers, the clients, don't get what they need. So ultimately, I think you feel as a matter of fairness, you need to sit down with this person and say you're not performing. And also you owe it to the person themselves to say, if you're thinking that they don't have a future there because they're not performing well, then you owe it to them to tell them that and to give them an opportunity to step up. So it's really about fairness. Ultimately, an employee is somebody who works mainly or only for you, and who their job is controlled and directed by you. Whereas a contractor is someone who works for themselves and contracts with a number of people, and who works under their own direction with some level of independence. And it doesn't matter if they have an ABN, it doesn't matter if they have their own company and all that sort of stuff. Ultimately, an employee is a factual test about what they genuinely do. So if somebody's an employee, then they're entitled to leave, entitled to superannuation and that sort of stuff, whereas a contractor, you can just pay a contractor fees. And if you're underpaying entitlements, you can get into all sorts of trouble. Foodora have argued that a whole bunch of what are employees are actually subcontractors or contractors, and therefore they haven't paid their minimum entitlements. And there's one with Woolworths at the moment, which is potentially $1 billion worth of underpayments. That kind of media scrutiny is not going to be welcome to any of our clients. We want to make sure everybody's paying their minimum entitlements. Obviously you want to be fair to the staff, but also you just don't want that kind of publicity. Even in my time in practice, I've noticed that there's been a real trend towards employee rights, in the sense that people used to underpay wait staff and that sort of stuff routinely, and people would say, oh, $10, $20, whatever it is, cash in hand job, and that was pretty normal, and it's just much more rare now. And 7-Eleven's a good example, right? It appeared that 7-Eleven franchisees were being routinely underpaid. That was a huge scandal, and you just can't afford to do that sort of stuff anymore. People will ring Fair Work, the media are interested in it. In my view, it goes back to managing the risks that your business face, and your workforce are a big risk. They can, sue you for unfair dismissal. You could potentially get a lot of brand damage if you've been underpaying workers, or if they just go out and tell everybody that you're a bunch of ratbags, that can be a real problem. If your staff are engaged and they're happy and they're properly paid and all that sort of stuff, they're likely to produce good results, they're likely to treat the customers well, they're likely to retain customers and so on. So it's really the employment law piece is a part of the kind of workplace productivity and success piece.